Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Hi, welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Real Estate Group, and today we're joined by our host Jim York and his guest Celia Deifik, attorney with the law group Ross, Lanier, and Deifik.
Thank you, Morgan, for the introduction. Well, we're here today with one of the local attorneys here, so maybe you could just introduce yourself and tell us a little bit about yourself.
Sure, Jim. My name is Celia Deifik. I'm an attorney with the law firm of Ross, Lanier, and Deifik. We've been together more than 20 years. I'm board certified in real property law and have been so since 1990. Recently recertified last year. I've got two great kids, lived in Southwest Florida for 35 years and grew up in Florida.
And where's your office located?
My office is in the Capital Bank building, downtown Naples. It's 599 9th Street North, which everybody knows is the Tamiami Trail. Big identifier is we're across the street from Pastrami Dan's. That's how people find us.
Okay, well, you know, we've had one of your partners on the show every month at our legal tip of the month, so we wanted to bring you on. Where do you specialize, in what area?
I litigate. That's all I do. I used to do some real estate transactional work. Now I leave that all to my partners. And I do particularly real estate litigation, being board certified in real estate law and having done real estate transactional work for a long time as well as litigation. At some point I decided that I should just focus on litigation, real estate and business issues.
Well, we had you come today to talk about a subject called partition. And I know it's a big subject here that a lot of people don't know about it, and it's about when people buy a property together or getting divorced or a death, how do they dissolve the property, right? If they can't agree on it.
That's true, that's true. And I have so many people come to me and they've been suffering for years with an ex-boyfriend or a brother or sister or someone who won't agree to sell the property. They don't need to suffer. There's a Florida statute called partition, and we usually refer to it as partition and contribution, because if one party's been paying more of the expenses, they can get that back. And this arises in a wide variety of situations. Often it is between a former wife and former husband, as you mentioned. It can be between ex-lovers, girlfriend and boyfriend who bought a house together, can no longer agree. Sometimes business partners. Often it's a scenario where a group of adult children have inherited their parents' property and no one can agree, one person's living in the house, and it just goes downhill from there.
And so if they can't agree on this, what are their options? Let's put it that way. I mean, you know, just start there.
Sure. Well, when people come to me, first of all, I tell them that partition is almost a matter of right. There's very few excuses or defenses to defeat a partition action. The court will almost always order the sale and will make the other party often pay part of the attorney's fees. So what I try to do to minimize expense to the client is first write a letter to the recalcitrant parties, send them a copy of the statute and say, listen, the court is going to sell this property and they're probably going to order you to share in the expenses. Wouldn't it be easier if we all list the property and come to some kind of agreement? So sometimes things get worked out and we avoid litigation. But if we can't, then I file suit. I ask the court for partition and contribution, and the court will do a number of things. First, the court will determine, is this property physically divisible? Or more often in Naples, it's a property that can't be split because it's a house or a condominium or something like that. So in that case, we do what's called partition by sale. Now, there's a number of different options. You can have the clerk sell it, you can have the parties agree to a private sale, or you can get a special magistrate appointed and authorize the special magistrate to do the things that the bickering parties cannot agree on. I generally try and start out with a motion for a special magistrate. I explain to the client, you're going to have to pay this person. It might be an attorney, an accountant, or something like that. But it so streamlines the process, because if the parties continue to bicker over small things, who it's going to be listed with, how much it's going to be listed for, what repairs are going to be done or not done, what appraiser are we going to use, the special magistrate who's appointed by the court would have that authority, and it just smooths the road.
Would he pick on how the property would be disposed of, like through listing the property or a sale or what?
Well, the statute gives options. One option is a public auction. Most parties, in their own self-interest, do not want a public auction on the courthouse steps because they're not going to maximize the value.
Right.
Another option is to have the clerk sell it. A third option would be a private sale by the parties, which would be through a listing. And another variety of that is private sale using the special magistrate. And again, special magistrate is not a judge. It's just a person that the court appoints.
Right.
And I sometimes will, for instance, select a real estate attorney who does real estate transactional work so that he can then do the closing, shepherd everything through,
Right.
and hold the money if the court has not yet determined who gets how much, because that's another portion of the partition proceeding that often takes up the most time.
In the value of the property, we were talking before the show, there's always some argument of the property, the value, and then maybe once you get an offer, what they would take. So who handles that?
Well, that's why I like to get a special magistrate appointed. Now, if the client does not want to incur the expense of a special magistrate, I understand, but I try to explain to them, you will probably save money in the long run, because the special magistrate is given authority by the court to do the things that the parties cannot agree on. And my experience is once the court orders a sale, orders it to be listed, and orders the parties to cooperate, but appoints a special magistrate, giving them this long list of powers, then the special magistrate will make sure a survey is done, an appraisal is obtained, a comparative market analysis is done, and so then the special magistrate has a good idea of what the listing price should be and what a bottom sales price should be. I always recommend to people in any kind of real estate litigation that we have a separate, off-the-record, confidential agreement as to what the floor price is that we will accept. So you have a scenario where one party says it's worth this much.
That's right.
The other party says it's worth this much. We have an appraisal that says this is where it is. So what we try to do is have an agreement that's not put in the court record that says, all right, we're going to list it high, but any offer we get that's more than this confidential number, the parties must accept. And if the parties fail to accept, then we can go to court to enforce that. So, as I said, many times the sale will occur before the court has had an opportunity to hear the issues of who has what interest and any contribution issues.
Okay, well, that's very interesting, and I think we're going to continue this subject on another part 2 of it, and then we're going to take a little short break, and we're going to be right back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back here. Let's talk about title issues, okay? So, and percentages and everything. So maybe you could explain that for our viewers, okay?
Well, one reason that people are often stuck in a constant, stagnant bickering stage is because they cannot agree on what percentage interest they have in the property. And sometimes you would think that this would be obvious, but often it's not, because the title has been screwed up. I can't think of a legal term, I'm sorry.
That's okay.
But there are multiple deeds. I've seen scenarios where a grantor, such as a father, deeded property to children in different percentages, gave them each different percentages. And then when one of the children was unhappy, said, well, I'll do a second deed, did a second deed, changing the percentages without thinking about, and delivered that, and recorded that without thinking about the fact that the first deed had already been recorded. So really all he did, in the first deed, he preserved a small share to himself.
Right.
So in the second deed, he was really only giving away tiny portions of the share he retained. There's so many issues in the title records I think people don't understand, and they don't appreciate why you should get a title search.
So he should have taken that first deed off? Is that,
Well,
would that solve the problem or not?
Well, he couldn't because he no
it was
longer owned the whole property.
Okay.
He only owned a small
certain
share.
Okay, that's...
What should have been done is that all of the children should have either deeded it back to him
and then redo it.
and then redo it, or deeded between each
Themselves,
other.
right.
Right. But, you know, we get into partition suits for so many different reasons, and sometimes it's a result of another lawsuit. For instance, an adverse possession suit, which establishes someone else has an interest or in a portion of a property. And so it's for the court to unravel this tangled mess. Now, in addition to all the legal issues that arise because of recorded instruments, whether they be wills or deeds or, you know, various other kinds of instruments, sometimes one of the parties is alleging that an equitable interest, such as a constructive trust, resulting trust, equitable lien. So they're saying, well, I might not be on the deed, but because I provided the money to purchase the property, or because I used my skill and labor to add on to the house, I'm entitled to, and you always promised me, a larger portion of the house. So the court is going to hold hearings to get all of that ironed out. And at the end, the court will come down with a number, whatever that number might be, and say Joe gets 20%, Susie gets 30%, and someone else gets 50%.
Okay, well, before the show we were also talking about that somebody's living in the house and the other person has moved out and had to pay rent. So how is that proportioned out?
Well, if the person who is living in the house has made it impossible for the other co-owner to live there, we call that ouster. And when you have been ousted, you're not getting the benefit of the use of your property.
Right.
You could be renting it. You could be living there and not paying rent elsewhere. So if there's a scenario of ouster, then the court is going to take that into consideration and say, once the sale is accomplished, the party who was pushed out the door is going to be entitled to the market, half of the market rent, or whatever the percentage is, from the party who maintained possession of the home. Now, that can arise in another scenario where one party has exercised dominion over the house, if you want to say it like that, put a tenant in and kept all the rents for himself. So that's another scenario where the court is going to forcibly make the other party contribute to the party who was cheated. And the way the court does that is by a court order that says, out of the proceeds of the sale, before party A gets their 50%,
Right.
the closing agent has to pay to the other party X dollars.
Okay. Wouldn't it be a lot simpler if they had an agreement prior?
Oh my gosh. Well, in 30 plus years, Jim, I can't tell you how many times I and my partners and my colleagues have seen people refuse to pay a few $100s to consult an attorney to
Right.
begin with and do
Exactly.
an agreement
Right.
and wind up losing $100,000 or $1 million down the road.
Well, we're going to take another little short break, and then we're going to come back and talk about legal fees, right?
Legal fees and other elements of contribution, yes.
Okay, well, we'll be right back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York real estate group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back. Let's talk about reimbursement of fees, okay? So maybe you could touch on that a little bit.
Sure. One of the concerns any client has when they come to me is, how long is it going to take and how much is it going to cost? Obviously, there's court costs and things of that nature, and there's attorney's fees. Meanwhile, often my client is the one who's been paying the mortgage and the taxes, making repairs, things of that nature. So we want to make sure they get reimbursed. So a couple of points. Number one, the first thing that I will try to do to minimize the cost to the client is send a letter to the other party saying, here's the partition statute. You're not going to be able to prevent the court from selling the property. Let's all sit down, work this out before we spend all this money.
Right.
Sometimes that works. Sometimes we need a pre-suit mediation. Sometimes that works. If there's so much discord between the parties that they can't even see past their own feet to get that done, then we have to go forward with the suit, and we ask the court not only to determine the relative interests of the party, but who should be reimbursed for their various expenses of maintaining the property, and whether the defendants should share any part of my legal fee. Now, what the court will do is the court will determine the services rendered and the benefit to the partitioned property, to the partition suit, and determine an amount of fees that is appropriate, and then the court can allocate those fees on a pro rata basis. So if the defendant has a 50% interest, the defendant might, depending on the court's decision, might have to pay a portion of my fees. Now, it also works the other way. If the defendant hires an attorney who investigates the title and finds a problem that he brings to light, an unclosed estate or something like that, or helps negotiate a better sale, then he has benefited the partition suit, and he may be entitled to attorney's fees. But the defendant's attorney would not be entitled to fees just for resisting the suit.
Okay. And when people are looking for an attorney, explain to our viewers, what is a board-certified attorney?
Oh, well, in Florida, we have a process where the Florida Bar certifies people as true specialists in an area. And the way they do this is very rigorous testing and educational requirements, not only at the beginning, but continuing over many years. And they also investigate each individual, particularly investigate their reputation, their ethics, whether there have been any bar grievances, this kind of thing, and send out letters to judges and attorneys in the community to determine the person's standing and reputation in the community. If the bar determines that that person truly is an expert in that area and has met all the requirements, they will be board certified, and then the bar requires that you be recertified every 5 years, which means you have to maintain those standards. So I'm fortunate enough to be board certified in real property law, and I have been since 1990. That's why I specialize in real property litigation. Interestingly, there's only a small percentage of attorneys in the state who have become board certified, whether because it's a time-consuming process or otherwise. I'm not sure, but it is certainly a benefit to the consumer because they know, well, this is a person who knows this area.
Exactly, right. Well, I thank you for coming on the show
Sure.
today, and I'd like to have you come back, and I think we talked about foreclosures, the process of foreclosures, and you specialize in that, also helping people, so in that area. So thank you for coming on, and
All right.
we'll see you again.
Okay, thank you very much for having
Thank
me.
you.